The courtroom felt colder than it should have. Not physically, no. It was the kind of cold that settled in your chest when you realized the story being told about you had already been rehearsed. I sat alone at the respondent's table, hands folded neatly, posture calm, while my brother took his place at the front like he belonged there. He always did that, occupied space as if it were pre-assigned. His lawyer walked beside him, clutching a thick folder with the confidence of someone who believed paperwork was the same thing as truth. Behind them, my parents sat in the first row, dressed carefully, solemnly, as if this were a formal ceremony instead of a legal ambush. I didn't look back at them. I didn't need to. I knew what faces they'd be wearing. When the clerk called the case, my brother stood immediately. He didn't rush, didn't hesitate. He'd practiced this moment. Your Honor. His attorney began, voice smooth and measured. We're here to request immediate protective relief. My client is seeking full control over his sister's assets due to her ongoing instability and her documented pattern of concealing property from the family. The word instability landed deliberately, like it had been sharpened beforehand. My brother turned slightly toward the gallery, letting everyone see the concern arranged on his face. The sigh he released was subtle but effective, just enough to suggest burden, not cruelty. Judge Merritt looked down from the bench with a practiced neutrality, the kind judges use to survive long careers. Ms. Lane, he said, glancing in my direction. Do you have legal representation today? I'm representing myself, Your Honor. That was all it took. My brother's smile widened, not enough for the judge to notice, but enough for me to see. He'd expected that. His attorney stepped forward again. We're requesting full transfer of all personal property, financial accounts, real estate interests, and any future proceeds. My client has supported Ms. Lane financially in the past, but this situation has become untenable. My brother leaned into the microphone. His voice softened. She's not well, he said. She's unpredictable. We're just trying to protect the family. A low murmur rippled through the courtroom. I felt it without turning around, the weight of strangers deciding who looked reasonable and who didn't. Judge Merritt tapped his pen once. Or Mr. Hale, he said, on what legal basis are you requesting full transfer of assets? The attorney didn't miss a beat. Guardianship, adjacent relief, Your Honor, temporary protective control pending further evaluation. It was dressed up in careful language, but the meaning was blunt: erase her authority, rewrite her life. Judge Merritt looked back at me. Ms. Lane, do you understand what's being requested? Yes, I said calmly. And your response? I stood. For the first time, I looked directly at my brother. Avon Hale, successful, composed, always the example. The man who never needed to raise his voice because systems bent for him automatically. He met my gaze with something close to kindness. Almost. While the judge shuffled documents, Evan leaned slightly toward me and whispered, just sign it over. You'll have nothing left anyway. I didn't flinch. Instead, I reached into my bag and pulled out a single sealed envelope. Your Honor, I said evenly, walking it to the clerk. I have one request before the court considers their motion. I'd like this entered into the record. The attorney let out a short, dismissive laugh. Evan's smile stayed in place, but his eyes narrowed just a fraction. Judge Merritt raised an eyebrow. What is it? A sealed notice, I replied. It relates directly to the inventory they're asking you to transfer. The judge nodded to the bailiff. Open it. Read what's necessary for the record. The bailiff broke the seal carefully, scanning the page. His expression shifted, not shock, but recognition. This appears to be an inventory notice attached to an asset disclosure, he said. The attorney frowned. Your Honor, we already submitted an inventory list. We'll hear this one, Judge Merritt replied. The bailiff took the attorney's folder and began reading aloud. Flat. Official. Item 1. Primary checking account ending in 428. He paused. Then he looked up. Not at the judge, at my brother. The room went still. Item 2. The bailiff continued slowly. A residential property listed as respondent's vacation cabin located in Hollow Creek, currently occupied by petitioner's family, marked for immediate transfer. Judge Merritt tapped his pen again. Ms. Lane, do you own property in Hollow Creek? I own what the record shows I own, Your Honor, I replied, which is why I submitted that notice. The bailiff glanced down at my sealed page again. Your Honor, the notice references a registry extract and an active restriction on the Hollow Creek property. That was the moment my brother's posture tightened. Judge Merritt leaned forward. Read it. The bailiff cleared his throat. The property is subject to a recorded restriction and cannot be transferred pending review. The initiating party is listed as. He paused. Then read the name, Evan Hale. The silence that followed felt heavy enough to press against the walls. And that was when I knew the story my brother had brought into court was about to collapse. Because the record was finally speaking back. But what the court uncovered next wasn't just a questionable filing, it was proof that my brother had already crossed a line he couldn't step back from, and the inventory list had only just begun. Judge Merritt didn't react right away. He didn't need to. The pause itself did the work, long enough for the name to echo in everyone's head, long enough for my brother's confidence to lose its footing. Mixtra, Hale, the judge said at last, voice level, did you personally file a restriction on a property you are now claiming belongs to your sister? Evan's attorney moved first. Your Honor, my client acted out of caution. The respondent has a history of concealing assets. This was a preventative step too. I didn't ask counsel. Judge Merritt interrupted, eyes never leaving my brother. I asked him. Evan swallowed. It was quick, almost invisible, but I saw it. I'd grown up watching him perform control. I knew every crack. I filed something, he said carefully. Yes, it was a precaution. She's unpredictable. I stayed silent. Silence, I'd learned, was dangerous for the person lying. Judge Merritt turned to me. Ems Lane, do you have documentation establishing your ownership of the Hallow Creek property? Yes, I said. And it explains why their inventory list is misleading? Explain. The cabin was purchased with funds my grandfather left me privately. I said evenly. It was never shared property. After his death, my brother accessed records he wasn't entitled to and filed a restriction under my name, without my consent. Now he's asking this court to hand him the same asset he already tried to freeze. Speculation? Evan's attorney snapped. It's timestamps. I replied calmly. And the digital signature used. The attorney frowned. Your Honor, that's technical. We'd need an expert. Do you have the logs here? The judge asked me. I reached into my bag and removed a thin packet, stamped, official, unembellished. I walked it to the clerk without haste. Judge Merritt scanned the top page. His expression changed, subtly but unmistakably. He looked at Evan. The filing account used to place the restriction, the judge said, was not your sister's. Evan's attorney turned sharply toward him. What? It was yours. Judge Merritt continued, voice calm. And the digital signature attached to the filing corresponds to an email domain associated with Hale Holdings. The words landed like stones. The bailiff, still holding the inventory list, cleared his throat. Your Honor, that directly affects item 2. The petition requests transfer of an asset currently under a restriction initiated by the petitioner. That may constitute an attempt to transfer property under a fraudulent filing. Your Honor, this is turning into a collateral dispute. Our petition is based on concern for her mental state and pattern of concealment. This court has authority to grant temporary protective control. Judge Merritt lifted a hand. This court also has authority to stop abuse of process. What I'm seeing is a petitioner who restricted an asset under his own account and then asked me to transfer it to him. That is not protection. That is leverage. Evan leaned forward. She's erratic, he insisted. She hides things. You may stop repeating adjectives, the judge said, and start answering questions. My father cleared his throat from the front row. My mother leaned forward slightly, lips pressed tight. Evan's attorney tried again, softer this time. The family is worried. At minimum, we're asking for temporary control of her accounts pending evaluation. Judge Merritt turned to me. Mems Lane, are you a danger to yourself? No. To anyone else? No. The attorney opened his mouth again, but the judge cut him off. I asked her. Then he nodded to the bailiff. Continue reading the inventory list. The bailiff looked down. Item 3, contents of respondent's safe deposit box, held at First Harbor Bank. He stopped. Not for privacy, because something else caught his attention. Your Honor, he said slowly, this item includes an access authorization number and a recorded access date. Judge Merritt's brow tightened. Read the date. 2 days ago. The silence invited conclusions. Judge Merritt looked directly at Evan. Did you access a safe deposit box you're claiming belongs to your sister? I have access. Evan said quickly. It's family related. Emergency contact is not access. Judge Merritt replied. The bailiff cleared his throat again. The record specifies access was granted via notarized authorization. That word, notarized, settled heavily in the room. Judge Merritt turned to Evan. Did your sister sign a notarized authorization granting you access? Evan hesitated, and that was enough. No, I said clearly. I did not. The judge's pen hovered. How do you know? Because I never signed one. I replied. And because the bank notified me yesterday that an authorization was submitted under my name. I reached into my bag again and produced another slim packet. This is the bank's audit confirmation, I said. It notes a signature mismatch. Judge Merritt scanned it. Then he looked up. This includes the notary commission number, he said. Yes. He turned to the clerk. Run it. Seconds passed. The clerk's face changed. Your Honor, the clerk said quietly, the commission belongs to a notary employed by Hale Holdings. The room shifted, not louder, sharper. Judge Merritt leaned back. I am denying any transfer of assets today, he said. I am issuing preservation orders. All communications, filings, and internal records related to this petition are to be preserved. Evan's face had gone pale. But the worst part, the inventory list wasn't finished, because when the bailiff reached item 4, it became clear my brother hadn't come for my money, he'd come for something far more dangerous. The bailiff hesitated before reading the next line. Not the polite pause of courtroom procedure, but the kind that comes when someone realizes the paper in their hands has just changed the direction of a case. Your Honor? He said slowly, item 4 is not a financial account or a property. Judge Merritt's eyes lifted. Then what is it? The bailiff swallowed once. It's listed as a document, specifically, an original will and trust amendment signed by Harold Caldwell. The name hit the room like a dropped plate. My grandfather. The bailiff continued, his voice careful now. There's a margin note attached. It states, retrieve from box once accessed. Evan's head snapped up. His composure cracked. Just for a second, but it was enough. Hale, he said evenly, are you listing an original will and trust amendment as an asset to be transferred? Evan's attorney jumped to his feet so fast his chair tipped backward. Your Honor, this is a misunderstanding. Sit, the judge said. The attorney sat. Evan cleared his throat. My grandfather had documents, he said. We didn't know where they were. We were trying to secure them for the family. The word family sounded thin now. Hollow. Judge Merritt turned to me. Mems Lane, do you believe your brother attempted to obtain estate documents improperly?
Yes,
I said. How? I didn't argue. I didn't speculate. I reached into my bag and removed a thin folder I'd been carrying all morning, sealed until the timing mattered more than the truth alone. I requested the bank's fraud hold file, I said. Not just the notarization session, the incident log and vault footage. The clerk stamped it and passed it to the judge. Judge Merritt flipped through the pages until his eyes stopped. A still image. Evan at a bank counter, holding a folder. Beside him stood a woman with her hair pulled back, posture rigid. Judge Merritt read the caption quietly. Attempted access, accompanied by notary employed by Hale Holdings. He turned the page. Another image. Another timestamp. Evan's hand flat on the counter like he owned the place. The judge looked up slowly. Mr. Hale, he said, why were you attempting to access a safe deposit box with a notary employed by your company, while carrying documents related to a will and trust amendment? Evan snapped. Because she was hiding it. The words hung there. Judge Merritt's gaze sharpened. She was hiding it. Evan glanced at my parents. You told me she would, he said, voice breaking. My mother's hands trembled in her lap. My father didn't move. Stop, Judge Merritt said. Then, quieter but harder, you are not in charge of this narrative. He turned to the bailiff. Bring me the inventory list. The judge placed item 4 directly on top of the bank exhibit. This court is making a referral, he said to the clerk. Contact the county fraud unit. Evan's attorney stood again, panic leaking into his voice. Your Honor, this is still a civil matter? Not anymore. Judge Merritt said. The attorney sat. Judge Merritt addressed Evan directly. You came into this courtroom asking to strip your sister of her property. Instead, the record shows you used a fraudulent filing, a corporate notary, and attempted access to a bank box to retrieve estate documents. Evan shook his head. You can't just... I can, the judge said. And I am. He denied the petition in full, granted a protective order, ordered preservation of all corporate records, digital logs, communications, everything. Then he looked at me. Ems Lane, are the estate documents in your possession? Yes, I said. I brought them today. Judge Merritt nodded. They'll be handled properly. As the courtroom emptied, Evan looked back at me once, eyes dark with fury. You think you won? He muttered. I think you got recorded, I said. It's already in 2 systems. Evan had never understood that charm can't erase a trail once it exists in more than one place. But what none of them realized yet was that The document Evan tried to steal didn't give him more. It guaranteed he'd lose everything he thought he was entitled to. By the time we reconvened, the court already had more paperwork than opinions. Preservation notices had gone out. The bank had locked its audit trails. The county fraud unit had opened a file. Hale Holdings had been formally instructed to produce internal logs, email headers, IP histories, and notary journals. Money can delay things. It can soften consequences. But it can't outrun timestamps. Judge Merritt took the bench with the same calm expression, but the room felt different now. Evan sat beside his attorney without confidence this time, hands clasped too tightly, jaw set like he was bracing for impact. My parents were there again, quieter, smaller. They still didn't look at me. The clerk called the matter, and Judge Merritt went straight to the point. This hearing concerns the submission of estate documents and clarification of beneficiary rights, he said. Ms. Lane, you may proceed. I stood and handed the clerk a sealed folder. These are the documents my grandfather entrusted to me, I said. They include his original will and a trust amendment. I'm submitting them under court supervision to establish chain of custody. The clerk stamped each page. No theatrics, no secrecy, just procedure. Judge Merritt reviewed the first few pages, then paused. His eyes slowed, not scanning now, but reading. Evan leaned forward slightly, like he couldn't help himself. The judge looked up. Mr. Hale, he said, are you familiar with the forfeiture clause in this amendment? Evan blinked. The what? Judge Merritt turned the document slightly, as if weighing whether to explain or simply let the words do the work. This amendment includes a provision, he said, that applies to any beneficiary who attempts to improperly obtain, conceal, alter, or control estate documents. My brother's attorney stiffened. Judge Merritt continued, it does not require a conviction. It requires evidence of attempted interference. The room felt suddenly smaller. Evan shook his head. That's not, he wouldn't. Judge Merritt raised a hand. The court is not speculating. The record already reflects attempted access to a safe deposit box, a fraudulent notarized authorization, and a margin note instructing retrieval of estate documents. He tapped the page once. This clause is triggered. My mother inhaled sharply. My father finally looked up. Evan stood halfway, then sat back down, like his body couldn't decide which reaction might save him. What does that mean? His attorney asked carefully. It means, Judge Merritt replied, that Mr. Hale's distribution is suspended pending the outcome of the fraud investigation. It also means he is disqualified from any administrative or fiduciary role related to this estate. Evan's face drained of color. You can't do that, he said, voice cracking. I'm family. That clause doesn't care, Judge Merritt said. And neither does this court. Silence followed, not shock, not outrage, just realization. I didn't feel triumph. What I felt was something cleaner. Final. The judge issued formal orders, continued note contact, continued preservation, supervised handling of estate assets. Outside the courtroom, things unfolded without drama. Hale Holdings was served additional notices. The notary employee was placed on leave. Evan's attorney stopped posturing and started communicating exclusively in writing. My parents sent an email 3 days later. 3 lines, vague regret. No accountability. I didn't reply. I archived it. Even apologies can become evidence when people rewrite history. Life didn't change overnight, but it stabilized. I picked up groceries, paid bills, made dinner. Ordinary things that mattered more now because they were mine. One evening, my daughter asked, "Are we okay?" "We're protected," I told her, because everything's in writing. Weeks later, the fraud referral moved forward. Slowly, methodically, exactly the way Evan feared most. The trust amendment did what my grandfather intended. It protected what mattered by removing power from anyone who tried to take shortcuts. Evan never apologized. He didn't need to. The record had already spoken. But the final twist wasn't what Evan lost. It was what the court realized he'd been trying to erase, and why my grandfather trusted me with the truth in the first place. The last hearing wasn't crowded. No audience. No tension thick enough to taste. Just a courtroom doing what it was built to do. Close a file once the truth had nowhere left to hide. Judge Merritt reviewed the final submissions without commentary. The fraud unit's preliminary findings had been entered. The bank's compliance report was complete. The preservation orders had done their job. Nothing disappeared. Nothing was altered. Everything Evan touched left a mark. That was the part he never understood. When Judge Merritt finally spoke, his tone was steady, almost gentle. "The court finds no basis to reinstate the petitioner's claims," he said. "The protective orders remain in effect. Mr. Hale will have no role, direct or indirect, in the administration of this estate." Evan didn't react. He stared straight ahead like he was waiting for a different ending to appear. The judge continued. "The attempted interference documented in the record is sufficient to invoke the forfeiture clause. Distribution to Mr. Hale will remain suspended pending final resolution of the fraud investigation." My parents sat motionless. They didn't argue. They didn't defend him this time. Silence had finally taught them what loyalty hadn't. Judge Merritt turned to me. "Ms. Lane, the estate documents you submitted will remain under court supervision. The clerk will retain certified copies. Originals will be secured according to statute." I nodded. "Thank you, Your Honor." The gavel came down softly. That was it. It kept moving. I drove home, stopped for groceries, bought cereal my kids liked without checking the price first. Small freedoms. Quiet proof. Evan didn't contact me. He couldn't, and even if he could, there was nothing left to say. Consequences arrived the way they always do when truth is documented, without drama, without mercy. Hale Holdings complied with production requests. The notary employee resigned. Evan's name stopped carrying weight in rooms where it once opened doors. He wasn't punished loudly. He was removed. One afternoon, a letter arrived from the court confirming what I already knew. The trust amendment stood. The estate would be administered as written. No revisions. No exceptions. My grandfather's words had survived exactly because they were clear. That was the irony Evan never saw. He tried to erase a document that existed to expose people like him. That night, my daughter asked, "Is it really over?" I thought about it for a moment before answering. "Yes," I said, "because now, everything that matters is written down, and protected by people who don't take sides." She smiled, satisfied with that. Later, alone, I opened the folder one last time. Not to reread the documents, but to remember why I'd waited. Why I didn't confront Evan the moment I saw the restriction. Why I let him keep talking, filing, signing, reaching. Because truth doesn't need volume, it needs patience. And when it finally speaks, it does so in ink, timestamps, and signatures that don't lie. Evan thought winning meant taking everything from me. He was wrong. Winning meant keeping what mattered, and letting the record do the rest. If you were in my position, would you have confronted him early? Or waited until the paperwork told the whole story in one hearing? Let me know in the comments. And if you want more stories where power loses to proof, subscribe and I'll see you next time.